Hi, everyone. I'm Judge Robson. Welcome to the program Answering the Call to Serve, Fundamentals for Volunteering for the Bankruptcy Pro Se Clinic. It's my pleasure to give the welcoming remarks and introduce the folks that we have here that are going to be speaking today. So first, I just want to welcome everyone who's here, and on behalf of all of the judges of the Middle District of Florida, thank you so much for those who are current volunteers, as well as those who are watching today and are thinking of becoming volunteers. We highly encourage your involvement with the Pro Se Clinic to give pro bono service and do all that you can to help those in need. So a couple of things that I wanted to say were that number one, the work that you do helps pro se litigants appreciate what we do in court, both as the attorneys as well as the judge, as well as make the system a better place for those people who are in times of distress and need of assistance. By assisting those in need, I'm reminded of quotes from Judge Edmondson that have been stated on multiple occasions with respect to interactions with federal courts. So I'm quoting from Judge Edmondson, so I can't take any credit for saying these wise words. What's important about the bankruptcy courts is that if an American citizen is to actually come into contact with a federal court in his or her lifetime, most likely it will be with a bankruptcy court. And his or her idea about what the federal courts are like, are they honest, are they fair, are they respectful? Those ideas will be formed from that contact. So, and so we look to our bankruptcy judges to be good ambassadors for the court system, as well as simply good judges. So I would add on to that in addition to judges being ambassadors for the court and for the system, I think practitioners who practice in the courts are also ambassadors to the system as well. Because again, the impressions that will be formed by the public who attend matters in bankruptcy court will be impacted by those of you who are in attendance. And so are you kind to them? Are you respectful? Even if you're litigating against them, I do think it makes an impression. So and obviously doing pro bono work, pro se work is very important because not only does it help the system, it helps the courts, and it helps your fellow colleagues with respect to administration of justice and the cases in an expedited or more efficient manner. Let alone it makes you feel good about what you do. And we all do have that responsibility to give back, when we can. And so anyway, so let me introduce some of the folks here who are going to talk a little bit about the different things that we have going on in the Middle District, as well as information that may assist you in providing services to those in need. So in no particular order, I'm just going to go by who I see on the screen. So first on my screen, I have Michael Schumpert, who is here. His name is on the screen, so you should be able to see that. He's with the bankruptcy court, and he's been amazing at volunteering his services for purposes of assisting with the bankruptcy pro se clinic. So he's going to be here to help walk through the portal and how easy it is to use, and how all of you can volunteer some of your time to that process. We have Kelly Petrie, who is typically a debtor's attorney in both Chapter 7 and 13 cases. A bit of background about helping guiding folks through representing debtors in the Middle District of Florida. Then we have Nicole Knoll, who is principally a creditor's attorney. And she's going to help walk through typical common creditor issues that arise in cases. And then we have Luis Rivera, who is a panel trustee. And I would say typically creditor's attorney when you're not playing your trustee hat, who has obviously extensive experience. He's board certified in both business and consumer bankruptcy. So we have a very well-rounded group of folks to encourage all of you that this can be done. It's not that hard. It won't take too much of your time, and it's really for a good purpose and benefit for us all. And I would be remiss if I did not thank Kathleen DeSanto, who is the wizard extraordinaire who helped put together the group, the discussion, help coordinate all of the logistics. And even though she says she's behind the scenes and no longer, I guess, the board member or something like that, we keep pulling her back in. So thank you so much, Kathleen, for everything that you do for us. So with that, I'm going to turn it over first to Michael, who's going to help walk through the Pro Se Clinic website. And so take it away, Michael.
Thank you, Judge. Good morning, everyone. I'm going to talk about our website, the Pro Se Clinic website. I'll give you an overview of the website itself, and then I'll show you what you'll see when you log in as a volunteer attorney. The first thing I just want to go over is the website itself. We have a number of links at the top here. Home, of course, is where we're at on this home page. Our story basically talks about the background of the Pro Se Clinic website. It was Orlando only, and we've recently expanded that to all the divisions within the Middle District. There's still some work to be done on the site. It's ever changing and evolving, but for now it is working for everyone. Who we are, again, just a brief explanation of who we are, what we do and what we don't do, what you're allowed to do as an attorney volunteer and what you should not do for pro se litigants. Why we do what we're doing. It's good for the community, for the profession, for personal career, and for the court, and good for everyone. And then the how button at the top, there's volunteer procedures, FAQs about volunteering, some client interview concepts, and some hypothetical situations. I do want to mention in the volunteer procedures, it does mention that in order to be a volunteer attorney for the clinic, you have to be admitted to the Middle District of Florida. When you submit a registration for the website, that is reviewed before you're given full access and be able to set up appointments. The moments and milestones needs to be updated. That's been changed as we went to the full district. So that's basically all that it has there. And again, the links are down here as well. For your purposes as volunteer attorneys, you would click register as a volunteer if you are not already on the list, and I can verify that for you if you're not sure. Again, you'll see Orlando here. That will eventually go away. Your name, email, phone number is all that we need for you to register. And then to click the part where it says, I am interested in volunteering for the Bankruptcy Pro Se Assistance Clinic, and submit. When you do that, I'll receive an email to let me know that you've registered for the website. And it's a two-step process. Once you've registered, I go in and actually add your information to the website as a volunteer attorney. And then you're able to then go in and update your appointment dates, availability, and so forth. And I'm going to show that to you now. On the home page, once you have your login and password, you'll see log in and log out in the upper right-hand corner. I brought up a second instance of the website and have already clicked log in and put my username, which will be your email address, and your password, which is provided by the site. The first page that comes up is your account and the calendar. If you have any appointments scheduled, they'll be noted here on the calendar with the name of the person that you're going to be consulting with. And the time of their appointment and so forth for that particular day. I'm in there as a test attorney. I don't have anything set up, so that's why it's blank for me. The next tab is the details tab. This basically has your information, your email address. When you put your phone number in, it will update that as well. And then it will also show the location where you primarily practice. You do have the ability to indicate more than one location. If you practice in both, say, Tampa and Orlando, you can put both locations there. And that's used by the pro se litigant when they, or pro se client, when they apply for assistance, they can select the location where they're at, whether it be Orlando, Tampa, Jacksonville, and so forth. The My Availability tab is where you set your appointment dates and times for your availability. I'm going to go ahead and follow the instructions here at the bottom to add an available day. And then if you have a date that you need to remove, it shows you how to delete that as well. So for now, I'm going to go ahead and add a couple of days. And let's say I'm going to pick the 28th and the 27th. Yeah. And you'll see down here, October 27 and 28. and I'll click apply. The 2 days now populate, and it's going to go from 8 to 6 p.m. For both days, and you can change this. If you're only going to be available, say from 2 to 6 each day, then you just simply change the times. And then if you have a break in between there, if you've got something else going on, you can add a break. Let's say we want to have a break from 3 to 4. No one can schedule an appointment between that hour. Simply save that, and there's your break. So when a pro se person comes in to make an appointment, they will see availabilities there from 2 to 3 and from 4 to 6 for your particular availability. Now, what I would do here is I would save, and then it will put those dates and times out there and make them available for folks to select, but I don't want to do that. So for right now, I'm just going to delete them, check the boxes, and then delete. And it will ask you, are you sure you want to delete? Okay. And then they go away. And that's available to you at any time. If you want to add availability anytime you want, it's available to do that. You also have a notes tab. This used to only appear with the client's name when it was Orlando only, but now the web developer has changed that. You can search by a debtor's name. It's going to show up as show active only, but you can select for show all, whether they're inactive or active. I've got to ask the web developer what that is for. I'm not sure. It will default to active only. And then the location. In this instance, it's Orlando. And it's going to pull up all the pro se parties that have had consults in Orlando here. And if this is someone that you have done a consultation with, you can select that name, add notes from your consultation. But I want to note that at the bottom, you'll see previous notes as well. Now, the question came up earlier about, can other attorneys see the previous notes? I believe at this point, yes. And I'm going to verify that. I'm going to verify that with the web developer because we had a training video from someone who did the Orlando appointments quite a bit. And when he did that video, there was no mention of whether or not those notes are going to be private from other folks. If another attorney comes in and provides assistance to this person, they would have access to the previous notes. But I'm going to verify that to make sure. And then you also have the ability to upload or download files. Same thing at the top. You can search for the client's name, the location, and the name of the person. And unlike CMECF, you can upload more than just PDF documents. You can upload Word documents, text files, PDF documents, and so forth. And it follows the same sort of process. You just basically click choose files, go to your browser, wherever you've got that noted, open it up, and it will bring it into the screen. And then if you want, you can put a description of the upload in there, whatever you want to put, and then click upload, and it will bring those documents into that client's particular screen. The pro se clients also have an ability to upload documents. When they get their login and password, they're given a link to the website to log in, and they will have an availability in the portal to upload documents for you as well, to be able to be aware of that before you have your consultation with them. When a person requests assistance, they're going to basically select a location depending on where they're located, kind of similar to where cases are filed within the district. In this particular instance, I'm going to select Orlando, and they can select either debtor or creditor consultation. And this is set up in your user account. Debtor consultation, I'm going to leave the date that pretend that it's me and I'm available today, anytime the rest of this week. And I'm going to just say between 7 a.m. and 6 p.m. and click next. Here's what the clients see. These are all the available dates and times that they can select from. It doesn't tell you who the attorney is, but it just, depending on who you select, or what time and date you select rather, will determine which attorney is going to get that appointment. So I'm just going to select 9:30 tomorrow morning. It's with Allison Moscato. This appears at the top at 9:30 tomorrow morning. No charge for the service. I would simply, when a pro se debtor comes in to do this, this is going to be blank. They'll type in their name, their phone number, and their email address. And then here's the waiver, the pro se clinic agreement for the limited advice. They read through this. And then this is their electronic signature at the bottom. They have to click to agree to the terms and conditions before they can move forward. If they don't click that box, they cannot complete the scheduled appointment. That's pretty much an overview of the website. If there are any questions, I'll take those now, or we can wait till the end of the session.
We do have several participants who have joined. So if anyone who joined the webinar would like to ask a question or make a comment, the chat feature is open, and we also have a Q&A feature. So feel free if any of the participants or attendees.
Michael, I had a couple questions.
Yes.
From an attorney's perspective. So when we were looking at the screen where the client could choose the service that they wanted, request assistance, it looked like they had a drop box. They can select the service, either debtor or creditor consultation.
Correct.
I didn't see a similar drop box on the attorney registration. Is that something you can limit yourself to?
Well, yes, it is. And in fact, when I do the second half of the registration and set you up within the clinic website, that's where we indicate that information. You can be set up for both debtor and creditor, or either.
Okay, so if somebody wanted to, they should just reach out to you, Michael?
They sure can, yes. And let me mention the website also while we're talking about that. It isn't on the PowerPoint presentation, but the website, I'm sorry, the email address is info@bankruptcyproseclinic.com. It's just like the website, except for instead of www. It's info@bankruptcyproseclinic.com. I check those emails every day, and I will answer you if you send a question. If you want me to review your account, or if you have any questions about updating your account, I'm more than happy to help you with that.
Another.
Oh, I have a question also. So for the folks who are being paired together, the person who's requesting assistance and the attorney who's volunteered, how do they get together? Is it through the platform, or is it separate phone call or Zoom, or?
It's a separate phone call. The attorney is expected to contact the client. You'll get an email when a client makes a reservation for an appointment, rather. You'll receive an email with their name, their email address, and the date and time of the appointment. Okay. Likewise, the debtor will also receive an email with your name as the attorney providing the consultation, with the date and time of the appointment.
Okay, so once the person who's seeking assistance makes, selects a time slot, an email goes to both parties confirming the date and time of the appointment, and then the attorney volunteer is expected to call the pro se individual.
That's correct.
Okay, I just wanted to clarify. And just before we continue, so I forgot to mention I wanted to give some statistics to everybody about the number of pro se filings in the Middle District of Florida, because I do think that that is helpful for everyone to know. So in 2020, there were 2,156 pro se filings. In 2021, 1,748, and then year to date 2022, 1,296. And that's across the district. So obviously, as filings have gone down, the number of pro se filers have also gone down, but it doesn't mean that the need is not there. And I do think that having this portal available will increase, the access to good advice. So anyway, I just wanted to add that as well.
One other question, Michael. So I serve as a panel trustee, and I primarily have a creditor's practice. I've registered to do both creditor and debtor consultations. What happens if, it turns out it's the debtor in one of my cases? Can I reject the appointment? How do you do that?
Can do that. Right now, it would be a matter of having to find another attorney to take that person for the consultation. We don't really have a mechanism in place at this point, other than to say, if you email us and let us know you have a
conflict.
A conflict. Thank you. A conflict. We can then put that word out to have someone else make another appointment, or we can direct the pro se litigant or debtor also to just pick another appointment date and time, so they don't have you as the person doing the consultation.
Thanks, Michael.
Yes, sir.
Michael, that was great. And you've stuck so closely on time. We're going to turn it over to Kelly. And
Thank
Kelly,
you.
if you want to talk a little bit about, you know, how to handle a debtor case.
Absolutely. I've been doing pro bono in Tampa, primarily through the Tampa Bay Bankruptcy Bar Association's setup that we have here. It has been an in-person clinic for many years. It, of course, shut down during COVID, and we did some by phone. It is up and running again. It's a really good program. We do it every Wednesday from 2 to 4. And we have a good participation from our bar. And I have learned a lot from doing that over the years about what are common things that you see from individuals who are coming into the Pro Se Clinic that need assistance. So I'd like to share my screen. Okay, so this was a PowerPoint that Kathleen put together for us. And I am going to skip down to information that I will be talking about. So the first thing that we should talk about is what kind of forms have to be filed with the court to initiate a case for a pro se debtor. Now, sometimes you will have clients, debtors, who will say, I need help filling out the documents themselves. And of course, sometimes there will be debtors who have already filed their case and they need assistance throughout the case, either a Chapter 7 or a Chapter 13. But if we are talking about doing a, from the beginning, preparing the documents, there is a very good place that you can go to. If you see, oh, that's my son and myself. Okay. Can you see the Middle District of Florida page?
Kelly, we can't. We still see you and Avery.
There we go.
There we go.
Okay. So flmb.uscourts.gov was established a few years ago, and there are very fantastic resources available here. Now, I direct your attention right to the center of the page right here called the source. This is something that Judge Jenneman started during her tenure on the bench, and it has become something that has been used significantly here in Tampa, and it's very useful throughout the Middle District as well. So if we go to here, filing without an attorney, before you file a case, there's a link for forms. So you choose what bankruptcy are you going to file. Let's choose 7. And this is the full list of documents that need to be filed to initiate a Chapter 13 or Chapter 7 case. Of course, an individual may file a bare bones case, which requires only the petition, the Social Security page, and the creditor matrix. But these are all of the documents that would be required to complete any kind of deficiencies. So this is where you can direct the debtor to go to obtain all of those specific things. Also, under the Chapter 13 tab, it includes the Chapter 13 plan. Okay, so part of what my specification in 13 is that please note that the Chapter 13 plan is a model plan. It is specifically designed to be used in all jurisdictions in the Middle District, that it cannot be modified or changed. You can't insert secret language in there. And the debtor needs to understand that they need to comply strictly by the terms of the plan. And we'll go over the plan and how to fill that out in a bit. Commonly, debtors were going to require some assistance with motions. Very common ones are things like motion for mortgage modification, a motion to extend stay, a motion to avoid lien. We'll go over some of those as well. Of course, there may be need to be an objection to a claim filed. We're going to talk about general objections and then also specifically dealing with an objection to the IRS because there are special service requirements for that. And then also there are, most of the time, the debtor will need to also submit an order and then serve that order once they have obtained the relief that they are seeking from the court. Okay, so here's the link that you can see that goes directly to the court's website for all of the procedures. Now, I typed in bold and capital credit counseling certificate. This is an absolutely mandatory document to be filed with the court. The debtor must complete a certified credit counseling course and obtain the certificate of completion at least before the time of filing the bankruptcy case. Originally under BAPSIPA, there was some argument as to whether or not it could be on the same day or if it had to be a day before. I think it's settled law that it can be on the same day, but it does have to be completed before the actual filing of the case. And that is one of the required documents to be filed with the case. Otherwise, that the court just simply does not have jurisdiction and has to dismiss the case. Of course, there is a very important matter of disclosing all of the assets that the debtor has. So when we are looking at the forms that the debtor is going to be filling out, and I'm sure everybody is familiar with all of the schedules. This is no surprise to any of you. But if you are not generally a consumer practitioner, the categories that you will be looking at may be different than what you're typically used to dealing with. So the first one is, of course, the homestead and any other real property that the debtor may have any interest in. That is a frequent one that is used, and also we'll talk about the exemption that goes along with that as well. Under Schedule B, vehicles, of course, and under the notation under Part 2, describe your vehicles, please do note that if you lease a vehicle, also report it on Schedule G, executory contracts and unexpired leases. So leased vehicles should be listed in fact, 2 places, Schedule B as a disclosure, and then as well on Schedule G as an executory contract. Of course, the most common categories that you will see are household goods and furnishings, electronics, collectibles of any value, hobby equipment, firearms, clothing, jewelry. Non-farm animals, if a debtor has a pet, you are supposed to disclose the hamster. Whether or not it has any value is an entirely different question, but disclosure is the most important part. So when filling out these documents, I think the trustees see frequently the absence of some items, especially by pro se debtors. So what I advise is for under household goods and furnishings and electronics, collectibles, sports and hobby, I call it the 2-hand rule. If you need 2 hands or more to pick it up, you should probably list it on Schedule B. And also just take a tour of the home. Walk in the front door. What do you see? Entertainment center, coffee table, couch, love seat, 2 end tables, etc. When we talk about value of all these types of things, it is not retail value. It is not replacement value if you are going to obtain a same item new. It is age and condition based on the item as it is right now. So generally that would relate to something like for a vehicle, you can look it up on Kelley Blue Book or the Black Book at ADA. I think different trustees have different preferences for where they find their values. As far as homes, the most common use you can do is under Zillow. Of course, it's not an exact science. We know that looking at a value under a property appraiser's website is going to be a low value. It's not going to be accurate. Of course, there's homestead exemptions and other things involved that alter what a true market value would be. For jewelry, electronics, things like the value from a pawn shop may be accurate for those. And then for your furniture, your clothes, well, that's usually fairly minimal unless you have relatively new items that may have still some significant value. The disclosure of bank accounts is always very important. It is not only a bank account that the debtor uses primarily, but also if the debtor is on a bank account with another individual. Commonly, you see that as a family member, an elderly mother or father, wherein their name may be on a bank account just for emergency purposes, and it would be considered a constructive trust. You would definitely want to list that under 17 deposits of money. And then you're also going to want to be sure that you reflect that on the statement of financial affairs as property held for another person. Again, to demonstrate that you have power and possession over it, but you do not have a true ownership. It's a bare legal title type of situation. A lot of the categories as you go through are not going to apply to many debtors. Annuities, trusts, patents, licenses, those sorts of things generally don't apply. You won't see those very frequently. Tax refunds are very important. As we are nearing the end of 2022 now, the trustees are going to begin looking at what kind of refunds the debtors will receive for 2022, because that will be considered property of the bankruptcy estate as well. So if a debtor has filed a tax return, for example, they filed their 2021 return late and they have not yet received it, if they file their bankruptcy case now, they must disclose what that refund will be, and that would be considered property of the estate subject to any exemptions that they have. If the debtor files now, the trustee may look at the prior year's tax returns as part of the documents that are mandatory production and see, oh, the debtor historically receives large refunds that are not earned income credit, which is an exempt source. And so they can choose to keep the case open until the debtor files their tax return for 2022 after the first of the year, because it's prorated by day of the year. So you take how many days have passed, divide it by 365, and that is the percentage that is property of the estate. And then, of course, then you apply any available exemptions. So debtors need to be sure that they're disclosing if they have not received any refunds, and also be aware that, especially towards the end of the year, tax refunds do become interests that trustees would be administering. Claims against third parties. Debtors may not necessarily understand what a claim is. It is, I think, as most of you understand, if there is any right that has arisen for you to make a claim against any other party for any type of injury or damages. This also includes class action lawsuits. Many times debtors don't think of that as being an asset. So good idea if you can inquire if they've received any of those cards in the mail, says they may be a party to this, or have they seen any of the commercials? The big one right now is Camp Lejeune. There's no, and many people think they may have a Camp Lejeune claim when in fact they've never even been inside the state. However, disclosure is always best. It goes farther down, and especially the last portion of it, it relates to farming and business equipment, which again is primarily not going to apply to the debtor. Okay, exemptions. The exemptions are available under the Florida Constitution, Article 10, Section 4, and under Florida Statute 222.5. That's where you will find the homestead exemption, the $1,000 of personal property exemption, the $1,000 of vehicle exemption, and if you're not a homeowner, you don't use the homestead exemption, then you get a $4,000 wild card, and that is, those exemptions apply to each individual. Even if it is in a joint case, those get to be stacked if it's a joint asset. So for example, if the individual does not own a home, but they do have a vehicle that is paid off, they can take their $1,000 of vehicle exemption and stack their wild card on top of that to exempt potentially all of the equity in the vehicle. I think the most commonly administered assets, or assets that are set up to be a buyback with Chapter 7 trustees, are vehicles. because in Florida, the exemption is quite minimal. It's only $1,000 of equity. So that is something that you can make the debtor aware of as well. Oops. The statement of financial affairs does have quite a bit of information that is applicable to the debtor. So it is important that the debtor fills that information out as thoroughly as possible. The first question is marital status. Okay, well, that one's pretty obvious. Then it goes into disclosure of income, both from your wages, or if there is a source other than wages, such as Social Security income, lottery winnings, inheritances, so forth. I would say the income section is a very important section to be sure to disclose very clearly. Another section that a debtor is frequently going to have to use, unfortunately, is where it asks if there has been any payment made on a debt owed to anyone who was an insider, question number 7. This is also something that frequently gives rise to an asset for a trustee to administer. If the debtor has made an insider preference within the last year, or in fact, under number 8 as well, made a payment on behalf of an insider, that absolutely needs to be disclosed, and that could potentially be subject to administration by the trustee. Any lawsuit that the debtor has been involved in, of course, definitely needs to be disclosed. And the debtor needs to be sure to provide on their schedules when they list the creditor, also the attorney of record, to be sure they're on the mailing matrix as well. Okay, I think the rest of it, everybody probably understands. Generally, debtors don't have any governmental unit responsibility of hazardous materials. So that was something that doesn't appear very often. Okay. So that's basically the overview of how to review the schedules with the debtor. Those are the highlights of things that the debtors need to be listing in their schedules. Let's talk about Schedule I for a moment. It can be a bit tricky for some debtors. It is based on gross income and then all of the expenses that are deducted by payroll. A lot of times debtors don't understand the difference between a W-2 wage and a 1099 type of income. There may be a need for a bit of explanation on that. As far as expenses go, it is Schedule J is based on actual true expenses as of the time that the case is filed, as opposed to doing the means test, which requires a 6-month look back period. So what you have for expenses under the means test may not be the same as what is on Schedule J, and frequently is not, and is sometimes an indicator that you can see clearly why the debtor has filed a bankruptcy, because that means test number is much higher than what their current income is, indicating a loss of income and a loss of disposable income.
And Kelly, is there a difference in Schedule I if it's a single filer versus joint filing? And
There
Chapter 7
is.
versus 13?
Yes, if there is an individual debtor who is filing, if the individual is married, then their spouse's income must be disclosed on Schedule I and on the means test as well as anybody else that may be in the household and contributing to expenses. So it's a full disclosure of household income and household expenses. When it comes to the means test, it's called heads on beds. If they're in the house as a residence, then any income they have or contribution that they make should be included. And using that individual as a household member for the determination of the appropriate allowances of the expenses would be adjusted therefore along with. Thank you, Judge. Let's talk about the Chapter 13 plan. Again, the terms of the plan cannot be changed. If there is a creditor that does not fit neatly into one of the sections, it must be addressed in Section E. Okay, so what is Section E? This is what a model Chapter 13 plan looks like when it's blank. Again, there's any of the forms that I'm going to be showing you today, I have available in a Word document format and would be happy to share with anybody who is in need of these. In Tampa, we do try to keep these types of documents on our computer that's located in the room where we do our Pro Se clinic. So volunteers can have access to these documents and help the debtors potentially fill it out and print it right there on the spot. So the first thing under the Chapter 13 plan that is what the debtor is going to try and figure out is what is their monthly plan payment? Well, that's really the last part of what you're going to figure out, because you have to determine what creditors are going to be treated in what ways before you can come up with the plan payment. So you're really kind of backing into the plan payment. When it comes to priority debts, which include domestic support obligations and the IRS, which is what you see primarily for consumers, is they need to absolutely be sure that they are listing anybody that they may have a domestic support obligation to. And even if the debtor is current, that individual, the recipient of the domestic support, should be listed as a creditor on Schedule E and should be listed as treatment on the plan. Even if they are current, it should appear there. The trustee's fee, there's nothing to fill in there because that is automatic. It is 10% across the board here in the Middle District of Florida. Now, under secured claims, there is a plethora of options to choose from here, and most secured claims are going to fit in one of these categories. So the first category is claims secured by debtor's principal residence, which debtor intends to retain, mortgage, HOA, and condominium association assessments and arrears, if any, paid through the plan. So, or as Judge McEwen likes to say, the cure and pay. The second one is claims secured by other real property, not homestead. Same categories, mortgage, HOA, and condominium associations. C is real property, whether it's homestead or non-homestead, that the debtor is seeking a mortgage modification mediation. Also noted, it explains very clearly in the paragraph that the motion for MMM must be filed within the first 90 days of the case. If the motion is filed after that, it will be automatically denied by the court unless the debtor has the ability to contact the attorney representing the creditor and get an agreement to proceed with the beginning of an MMM at a later date. There's categories for claims secured by real property or personal property to which Section 506 valuation applies, a strip down. This is usually where you're going to put your vehicle loans if they are not 910 cars. What that means is if you have purchased a vehicle or refinanced a vehicle within the previous 910 days before filing bankruptcy, you cannot modify the principal amount that you will be paying on that debt. You can cram down interest, and that is what is called the till rate. Right now, till is, I believe, about 8.25, somewhere in that range right now. For a long time, it was about 5.5, and since LIBOR has gone up, so has the interest rate for till. So the debtor needs to be aware they can change the interest rate on a vehicle. If you've got a double-digit interest rate, it might be beneficial to do that.
And as the plan notes, a separate motion has to be filed. It's while it should be in the plan, a separate motion should also be filed.
Correct. And there is a difference in the procedure between Tampa and Orlando. In Tampa, the plan rules based on the interest rate unless the creditor objects to it. In Orlando, the proof of claim rules unless the debtor files an objection, which is referred to as the till objection, to specifically state that it should be a different amount on the interest rate. Yes, Judge, thank you for that. Payments on claims secured by real property and other personal property to which 506 valuation does not apply. So frequently what you're going to see here is furniture. We used to get vacuum cleaners. We used to get dogs. Yes, I have crammed down a dog before. But vehicles are generally what you'll see there. Sometimes other things. Secured claims paid directly by the debtor. So for example, if the debtor has a homestead, they're current on their mortgage, it is not a requirement to pay it through the plan here. So you can put that directly outside the plan. They continue to make their payments to the creditor. Also note there is instruction under the paragraph, the automatic stay under 11 USC sections 362A and 1301A is terminated in rem as to the debtor and in rem and in personam as to any co-debtor as to these creditors and lessors upon the filing of the plan. So if the home or the car or the furniture is being treated outside of the plan, the automatic stay does terminate by operation of filing this plan. The creditor does not have to file an additional motion to obtain relief from the stay. There's a category, secured claims that debtor does not intend to pay. I have never used this section. If anybody has an experience with anybody using that section, what have you maybe seen that was been inserted there, Nicole?
The debtor does not intend to pay. Typically, it's when the debtor intends to continue to fight the foreclosure. So under the FIAA decision, that was the 11th Circuit, surrender now means that if you propose a plan that provides for surrender, you can no longer go back to state court and continue to defend the foreclosure. So what I typically see is if a debtor does intend, they believe they have certain affirmative defenses or causes of action in a foreclosure action, they'll put it in the debtor does not intend to pay. And that allows them to forego the surrender conflict and then go to state court. But I will note, this does say that the debtor does not receive a discharge of personal liability on these claims. So that's an oftentimes, large gamble to sometimes make if that's your position. That's where I see it. I don't know if anybody else has any other comments. Oh, also sometimes I see things put here, if there's co-obligors and there's some type of divorce decree where they're responsible for it and they don't want to have it discharged. I have seen collateral placed here too, if there was some type of divorce decree in the past.
And for example, like the co-obligor would be the one paying it. So the debtor is not paying it, but someone else may be paying it.
Right. So in essence, debtor does not intend to pay. So they'll move it out. Yep.
Okay, good. I think those are
Kelly, if I could
solids.
interject there, the co-debtor stay terminates. So if the co-debtor's paying, you wouldn't want to put it there necessarily.
Okay, a consideration, Louis, thank you. Now, if the debtor has a lease, which could include a residential lease, a vehicle lease, any other type of lease, those specifically need to be mentioned in the plan as well. So the first choice is assumption of the lease or an executory contract for real or personal property to be paid and arrearage is secured through the plan. I don't use that one very frequently, but it does come up sometimes. B is assumption of the lease executory contract for real or personal property to be paid directly by the debtor. This is what you would see most frequently when you have a lease situation. And then there is also the rejection of the lease. So those are the categories that you have to fit a secured claim or a lease or an executory contract into. If it doesn't fit into any one of those categories neatly, you can avail yourself of, as we scroll down, paragraph E, non-standard provisions. And there is a notation, any non-standard provision is planned other than those set out in this section are deemed void and are stricken. So that avoids, debtors trying to slide in there somewhere that their student loans are going to be discharged with the bankruptcy as well. That doesn't fly anymore. There is a section here to put the pro rata distribution to the unsecured creditors. So this is where you put in a dollar amount that is equal to either what the liquidation amount requires for non-exempt assets or what the means test reflects as being disposable income on a monthly basis times 60. and it is whichever number is higher. So it is a pot plan. The trustee is going to disperse based on timely filed claims and on a pro rata basis to these unsecured creditors. There is a box to check down here, and this is something that you should consider carefully before checking the box. Under number 3, you choose either property of the estate shall not vest in the debtor until the earlier of debtor's discharge or dismissal of the case, unless the court otherwise orders, or the property of the estate shall vest in debtor upon confirmation of the plan. There are lots of different reasons why you would want to use one or the other of those. I most always use the first option, subparagraph A, but there are alternatives to that that may not necessarily affect somebody that you're representing on a pro se basis. It can be a bit more of a deeper concept. And the plan does then require the signature and the date of the plan. Of course, it's got a signature blank for an attorney because I made this, there's no attorney. And at the bottom of this document and any other document that may be prepared for a debtor, we always should include the language, this document prepared with assistance of counsel. We don't want to make it appear that we are representing a client without that being disclosed. We don't want it to appear that the debtor may have paid someone for assistance for preparation of documents without disclosure. So we always put this disclaimer down at the bottom of each one of the documents that we provide to the debtors. All right, the most common motions that you're going to see when you are assisting a debtor in a pro se clinic is primarily Chapter 13 work. There's not a lot of motions. There's only really 2 motions I think that would apply in a Chapter 7 most commonly seen. So the first one is a motion to extend automatic stay. If the individual has had a bankruptcy case that has been pending within the previous 12 months before the filing of the instant case, then the automatic stay will terminate 30 days after the date of filing, unless the debtor files this motion to extend the stay. This motion must be filed within the first 30 days. I think the preference for the judges is 7 days after the filing of the case, so that they can timely get it onto their calendars to make consideration. There is a bit of a different standard if it is the second case that's been filed within a 12-month period. Then you must show a substantial change of circumstance. If there's been more than one, it's a higher standard. The debtor must have a really, really good justification for having had 3 cases pending within a 12-month period of time. Frequently, these motions go unopposed. The Chapter 13s usually have something they like to add in to the judge's commentary. But if it is a repeat filer, and they don't file this motion to extend stay, there is no automatic stay. If it's the second filing after the 30 days, if it's a third or more, then no stay comes into place at all. So those lawsuits are not stayed, that foreclosure is not stayed. There's all kinds of things could still proceed for activities if you do not extend the stay. Judge?
So, well, I was just thinking, if it's a pro se debtor who already filed their own case, they're not going to know they need to file this motion. So if they come to the clinic and they say, you know, you spot this as an issue, is there something that they can do, you know, even if it's after the 30 days? So,
Yes.
yeah.
Yes, Judge, there is. You can file a motion to reimpose the stay or to impose the stay. I think it would be a lot of the same language that would be in this motion. You would just need to change the title and the body a bit. But if there is justification, such as it was a pro se debtor, they did not understand this requirement and they simply missed that 30-day window of time in a second case, a motion to reimpose the stay would usually be looked upon favorably by the court, with, of course, justified reasoning.
Unless Nicole objects. for some reason, or her client, I should say.
Also, I just caution, the plan has to also agree with whatever the debtor is requesting. Oftentimes we see pro se debtors who file plans that list paying no one, but then are seeking imposition of the stay or extension of the stay. And then the language in our plan and administrative order would control. So I always caution, I send every pro se debtor to the clinic for that very reason, because there are nuances there.
Okay, so that is one of the motions that you'll see. Negative notice. I don't know how much each individual attorney wants to try to explain to a pro se debtor about how negative notice works. I would leave that up to each person to determine how sophisticated they believe the debtor is and whether or not they would understand the concept to be able to handle it and execute it properly. There is, again,
I think on that
frequency-
issue, Kelly, I would say more of advising pro se debtors, probably, right? That something can happen without a hearing, right? So if you make sure to read whatever papers they may receive, because, for example, a creditor may say they want to get the home out of the bankruptcy, and they can do that on negative notice. And so if you don't file a response timely, it will likely be granted. So I think that's something they should just at least know, not that they may want to use negative notice themselves, but that they may be, subject to it.
Absolutely. I do frequently meet with individuals who have received documents and they say, I got this letter from the court, I don't know what it means. So as much effort as the court puts into making language that is plain and clear and understandable, many people are simply intimidated by anything that appears to be legal speak. And so it is also something that you would be assisting individuals with when they bring in that motion for relief from stay, or they bring in some other document or pleading, a motion to compel turnover from a Chapter 7 trustee, a motion to dismiss a case for failure to turn over a tax refund from a Chapter 13 trustee. So that is a time when a negative notice would be very important for a debtor to know about and to timely respond to that if all possible. Okay, one of our, another common motion that is filed is a motion to determine secured status. So this includes negative notice on it, just because I have that as my format. Again, it's not necessary for it to be used by the debtor. The primary important information to be included is to properly identify the asset. For example, if you're, well, a few years ago, not so much anymore, we were stripping off a lot of second mortgages in Chapter 13. So if it is real property, am I not looking at the right one? Oh, I didn't pull up the right one, sorry. If it is real property, then it needs to be identified by both the property address and also by the legal description. Anything that is referenced as real property in any type of motion needs to include a legal description. If it is a vehicle, it needs to include what the VIN number is. It is usually a motion to determine secured status is most frequently filed after the proof of claim is filed. So if the proof of claim, for example, from Badcock includes a listing of assets, then generally what I would say is list every single one of those items that are on the purchase order, and then you can refer to it specifically as furniture or household goods and furnishings. So what it is that you are trying to determine the value of needs to be very clearly specified to give the creditor proper notice. You have
And
to
also,
say what
I have seen this, so I'm sorry to interject again. So, okay, I would say also make sure that the debtor understands they need to list if they're going to try to do this type of thing, list the property as exempt on their Schedule C, as well as list the creditor in their schedules, because I've had cases where the creditor wasn't listed, the asset was not claimed as exempt. I mean, that you can't do this type of motion.
Yes, it is very important to tell the people that you are modifying that they are actually being treated. So yes, full disclosure of any creditors on schedules D, E, or F, specifying, as Nicole said, how they are to be treated in the plan. And then if your motion is then filed, to very clearly identify what the collateral is. For a certificate of service, I think all of us know what goes on a certificate of service, but a debtor may not know how to find that information. The best resource is the Florida Division of Corporations website, sunbiz.org. They can go on there frequently and find the name of a registered agent, an officer of the company. And then, of course, you do need to serve the address on the proof of claim and the individual who filed the claim. So assisting them with creating an appropriate certificate of service is also something that is very helpful for many debtors as well. Oops. Okay, another motion that is common in both 7 and 13 is a motion to avoid a lien. So this is the motion to avoid lien on homestead. So first, as was pointed out by the judge, if you want to avoid a lien that is impairing an exemption, you first have to apply the exemption on Schedule C. This is a draft of a motion to exempt a homestead. So you specify the address, the legal description, and how did that lien come to be? You need to explain where it came from. Identify if there was a certified judgment that was recorded in the official records of Hillsborough County on a specific date, in record book, page, and instrument number. That information is all readily available on clerks across the state's websites that I have found. I haven't encountered one that I wasn't able to access as a public record that was available as an anonymous user. So you need to have that information to be sure that you are avoiding the proper lien itself. And again, service is very important on this as well. Motion to redeem. This is a Chapter 7 concept, and we don't get to use it very frequently. I do use it in some circumstances. Now, again, how much do you want to get into trying to explain processes and background information to a debtor? When you are redeeming collateral, you have to pay what the fair market value of the collateral is rather than the full contractual amount. It has to be done in a lump sum payment. Most debtors don't have that lump sum payment available. However, some can get very crafty. They can potentially obtain a loan from a friend or a family member. There are companies that specifically will loan to people who are in bankruptcy. The section of the bankruptcy code that specifies the terms of redemption is section 722. There is a company called 722 Redemption that specifically operates under the idea that they understand they are working with debtors that are in bankruptcy. They understand that the loan is going to be a high risk loan. It's going to have a higher interest rate, but if you have a car that is extremely upside down because perhaps you traded in something else and traded in something else and then traded in for this car, and you've got lots of negative equity that rolled over and over, then that frequently can be very helpful for a debtor. This can also be used to redeem personal property, which is much easier to pay. For example, if you bought a bed from Badcock and that bed's about 5 years old, but you still owe $1,000 on it, that bed may be worth a very de minimis amount of money. And so it would be easy to redeem that type of collateral. Again, service is very important on this part. And this also can be done with negative notice of 21 days. Oh, and again, on each one of these documents I've been drafting, I have been including at the bottom, this document prepared with assistance of counsel. So I think it's important that we include all that information. Okay, objection to claims. Now, almost in every case, a creditor is going to disagree with at least one proof of claim that gets filed with the court. To file an objection does require a bit of creativity sometimes. I think everybody who will be viewing this has filed an objection to a proof of claim at some point. It is a little bit different in the world of consumer practice because they are much smaller, isolated types of issues. The most common objections that I see are usually to the IRS. It is very important that debtors have filed all tax returns that have been due to the IRS. The code requires within 4 years before filing, but if you have unfiled from back in 2016, the IRS is going to file a proof of claim. They are going to estimate an amount in there, and you are either going to have to file an unfiled tax return and be sure the IRS processes that properly, or object to the claim and say, I did file my tax return, provide a copy of the tax return to the individual who files the proof of claim with the IRS so that they can make any correction in their system to update what the figures may be for a proper claim on that. One objection that I file fairly frequently that again may be a bit sophisticated for a pro se debtor, but is a objection based on the statute of limitations. So if you see a creditor filed by LVNV or CACH or Pinnacle, it is probably a stale claim. And what that means is, as I put inside my proof of claim here, Florida Statute 95.112B requires that an action on a contract founded on a written instrument has an enforceable period of 5 years. So if you have a debtor who has a liquidation issue, they're going to have to pay a fairly large amount of their unsecured debt. But a whole lot of those proofs of claims are untimely because they've exceeded the statute of limitations time. It is important to object to those claims to get those tossed out, to potentially have the debtor pay an even lower amount than liquidation or disposable income requires. And no, it is not a violation of the automatic stay for the creditor to file that type of claim. It is up to the debtor to catch that it actually was filed. For the Internal Revenue Service, again, a frequent objection that gets filed, and the IRS is a bit different because the proof of claim, the certificate of service is much more extensive. So that it needs to be filed on the person who has filed the proof of claim. Usually that address is in Philadelphia. Sometimes it's in Jacksonville. So you do have to look very closely at the claim to see where that individual is located. There's also required to file it, provide a copy to the IRS at the special procedures in Jacksonville. Also to the headquarters in Philadelphia at a PO box. You also must serve the Attorney General of the US. You must serve the US Department of Justice Tax Division, and you must serve your local US Attorney's Office. Realistically, I think the person filing the proof of claim and the local US Attorney's Office are going to be the two that you're going to be hearing responses from. And that usually is going to be either we don't have your tax return, or if there is a dispute as to whether or not the tax itself is dischargeable. Has it been categorized as a priority when it should in fact be just general unsecured? But this is the most important takeaway at this point for an objection to the IRS is who all does need to be served on the certificate of service. If there is no response filed to a motion that is served with negative notice, if the debtor has served something that does have negative notice, and the debtor needs to submit an order to the court. This is an example, and it has the language in it specifically, I think we're all familiar with Local Rule 2002-4, saying that the motion was filed pursuant to the local requirements and that there was no response that was filed. And then a simple order. It doesn't have to be very complex as to what is granted. Now, if the debtor is coming to you and they serve their motion and they're trying to craft an order, of course, be sure that they're not trying to include any extra information or extra relief in a motion or an objection that was not pled in the original motion or objection. It's not an opportunity for the debtor to ask for more than what was originally requested. Of course, I think we all understand that, although pro se debtors frequently do not. And then, of course, in 13, let's talk about the MMM order, motion, I should say. This is a very standard form order motion. The motion has to specify the name of the mortgage company, the creditor that is holding the lien on the property that you are seeking the modification with. It must contain the actual physical address of the property that you are looking to modify the mortgage on. Legal description is not required here. And it must include the last 4 digits of the account number. Now, who does this have to be served on? Well, if there is an attorney that has filed a notice of appearance, then definitely the attorney. If there has no attorney made a notice of appearance, then you do need to serve, again, generally what you can find on the Sunbiz website as to an officer, the registered agent, and the primary mailing address of the creditor. The order on MMM is a standard order that is issued by the court. That is not something that is drafted by the filer of the motion. The order has specific dates and deadlines, and I don't recall where I saved.
It's on the source, Kelly. It's the source
It's on the
page,
source, right?
mortgage modification, mediation, and their procedure manual. It talks about everything that an order will include. Selection of a mediator, timelines for uploading the portal. Yep.
Okay, so let's go.
Right there, Kelly, you just passed it. Bingo.
There we go. Motion, mortgage modification mediation. Oh, this is not what I was looking for.
Go back one step. And then the top, very top link, the procedure, it's under that. They don't actually have the order, but they do have all of the requirements listed.
Is that all the requirements in there? Because I had a copy of the order itself. I just don't have it.
Yeah, the order is not published because I think it's a court order, but it
Yeah.
has all of the rules, the following terms apply.
So as I had referenced earlier, when you go to the home page for the Middle District, in the center is a link called the source. When you get into the source, there are many different categories of information that you can access. So if you go to the procedure manual and forms, You can then do a pull down to the mortgage modification mediation, and then you can choose to look at what are the requirements. And this is something you probably just want to refer the client to review. They need to be familiar with this. Of course, they will receive specifically an order from the court that has all of the deadlines and requirements in it. And they are fairly, most creditors are fairly stringent with complying with the deadlines as well as document presentation. Now, when a debtor is using a motion to seek a modification, the actual process itself is conducted through a portal. It's the DMM portal. That is what is the best method we've found to be able to have concentrated information and all parties available for communication in one spot. So the debtor would upload their documents, and it's things like pay stubs, tax returns, bank statements. They have to fill out several different forms. There's the uniform borrowers form. There's so many different things, and it can be a bit onerous, but there are many debtors that have been very successful in completing a loan modification, but they do need to pay very close attention to the details that are required for creating a full package to submit to the mortgage company. The order does require that the process be completed from the time of entry of the order until the resolution, being 150 days, which seems like a very long time when you're standing at the front of it. But it can become a bit of a race to the finish if, for example, there's been a change of circumstances and the debtor has to provide updated information. What they provided was stale, if there's been a change of circumstances. So that 150 days is a very reasonable amount of time to get it done, but don't wait until day number 90 to start submitting documents after the entry of the order. And then also here you can find when you are approved for a temporary loan modification, that does need to have a motion to approve that filed with the court. And then once the trial is completed and there is a permanent modification, then there is also a motion for approval of a permanent modification, which then becomes terms of what you would want to include in your Chapter 13 plan. So if your terms were not precise, and generally they never are, then you do need to file an amended Chapter 13 plan that includes the specific dollar amounts provided in the mediation order as to what the terms for repayment are. Be sure you have that proper monthly amount. Okay, so there are lots and lots of other things that I could discuss. I'm hoping to just provide an overview of things that you need to get kick-started with advising a debtor in a pro se situation. The thing that I think is most important is practice. As everything else, practice makes perfect. The more that you expose yourself to the knowledge, the better you're going to become at advising pro se debtors. It does not need to be, you don't have to go in and do a complete analysis, like a consultation with them and advise them exactly what they need to do to lay out their case. This is more of, here's how we can help you fill out your documents. Here's what these documents mean. Here's what you need to do to be able to have a successful case. And those can be done in small bite-sized chunks, like as Mr. Schumpert was showing us earlier, the calendar has 30-minute blocks of time. So this is just a short amount of time that you can really provide the assistance to a debtor that can make or break the success of their case.
Okay. Kelly, does that take us to my portion on pro se creditors, or was there any?
Did I take up enough time, or should I talk about something else?
If you have other things to talk about, I think we do have time, but if not, I think we could move on if you wanted to. And with the creditor, I'm going to say this, when I get to the creditor's rights portion, and I'm going to talk a little bit about my experience volunteering as a creditor's lawyer in the pro se clinic. on and assisting debtors, both you and Luis should definitely chime in because you're going to be very knowledgeable about it. If you could actually keep up the PowerPoint, Kelly, and wouldn't
Oh,
mind
sure.
driving for me for a little bit. So my name is Nicole Knoll. I am a creditors' rights attorney. Primarily, we don't necessarily see a ton of pro se creditors in the program, but they do exist. And when we see them, they usually fall into certain categories, candidly. So the first thing I'm going to talk about is the, pro se representation or pro bono representation, assistance in the pro se clinic of unrepresented creditors. Kelly, I think you said it best. When you're talking about debtors, that oftentimes they get something in the mail and their first question is, what is this? What did I just receive? And creditors are no different. They're not the party that brought us to the bankruptcy court necessarily. So oftentimes they're not sure why they're included, or they're not sure what this letter that they received, whether it's a notice of bankruptcy case, a notice of proof of claim deadline that they received from Luis's office, or some other document, whether it's a 341 meeting. So oftentimes the consultation with a pro se creditor starts the same way it does with a pro se debtor, is what brought you in today? And usually it's some type of pleading from the court saying, I got this in the mail. What do I do with it? What are my responsibilities and what do I need to do? The most common, especially if it's in the beginning of a case, is going to be the 341 meeting. They've received notice they need to attend in a meeting of accreditors, not realizing that that's really a meeting directed at the debtor for the debtor to provide testimony, and creditors have the option to appear if they want to ask any questions. Oftentimes creditors misinterpret that. The other item that usually comes across my desk is, I received this notice to file a proof of claim, and what do I do with it? I don't even know who this debtor is sometimes, or I'm not sure why I'm being listed, or my personal favorite, the debtor told me I'm not included in their bankruptcy, so I don't know why I'm getting notice from the bankruptcy court, which of course is a misnomer, because if it's a debt, it's included in the bankruptcy. So on a proof of claim consultation where someone is coming in saying, I received this from the bankruptcy court, they're telling me I need to file something. The most important thing to mention, at least one of the most important things in my opinion, is the proof of claim deadline. Because ultimately, if the creditor misses that deadline, they cannot really unweave or unravel that problem. Especially if it's unsecured and you're in a chapter 7 or even in a chapter 13, it's very difficult. And what you historically see at the pro se clinic from a creditor's perspective is going to be an unsecured creditor. So the proof of claim form can be found at uscourts.gov, same place that Kelly just went through very well. On the US Courts website, go to bankruptcy forms. It's under the 410A provisions of the forms. What often gets lost, and I think is a great tool, is that on the same link to the 410A, which is the proof of claim form, there's also instructions. And the instructions were amended in, I believe, 2016, and were really effective, in my opinion, on explaining to a creditor that maybe does not have any experience with the bankruptcy process, the difference between a secured claim, the difference between an unsecured claim, what types of priority claims someone may have under Section 507, and what those, why you may have a priority claim under 507. So even after doing it, for 14 years and filing thousands of claims, I still sometimes go back to the instructions and the forms to say, well, what do I need to do in terms of, Kelly, if you want to go back one issue. Yep. The form instructions. Oh, it's okay. It's okay. I'm just going to comment it on and then move on. So the form instructions are actually really helpful. If you have a pro se creditor in front of you, to even just provide them a copy of it so that they because it is a good primer. Again, communication and discussing, there they are, the instructions for the proof of claim. It goes through what is a secured claim, what is an unsecured, different types, at least priority claim and why you may have a priority claim, and also what types of documents for support. Oftentimes a pro se creditor is not going to know about the statute of limitations, and they may come up against either a question from the trustee or an objection by Ms. Petrie in the event that they file a proof of claim for an obligation and did not include the proper documentation to show the trustee or debtor's counsel that whatever claim they're filing is within the statute of limitations. That could be as simple as they failed to provide copies of the contracts that the claim arose under, or actually an accounting of any types of payments that were received, which are required. So when a creditor comes in and is discussing the type of relationship that they had with the debtor, it's not always a one size fits all. It is very rare that you're going to have a mortgage creditor come in to a pro se clinic. I'm not saying it could never happen, but those types of creditors in terms of mortgage debt are typically going to have counsel, even individual investors. So what you're typically going to see is an individual that is either has a claim against the debtor through a personal injury claim, or might, if it's a corporate debtor, might have been a past employee of the company. So I always like to meet with the pro se creditor and see what the background is, how this could have arisen, and also talk through, okay, if you were an employee, how long were you employed? When were you last paid? When did you last work? If we go to page, I think it's 2, it might be 3. Kelly, go down 1, please. One more. There we go. So at the top, up 1, sorry, Kelly. Here on section 12 of the proof of claim form, it actually does give a little highlight of the 507 A priority claims that you can have. And I just want to direct everybody's attention to 507A4, because that's one of the most common ones I see, which is for unpaid wages. You can have a priority claim. I believe they change it yearly, but I think it's 15,000, maybe 15,500. If there were unpaid wages within the 120 or 60 days that were before the bankruptcy filing. Other things I like to point out on the proof of claim, this is not the time to guess. This is signed under penalty of perjury. There are repercussions if you file a fraudulent claim. This is not the time to air, what you should have won potentially in the appeal that you lost, and now you think you're going to relitigate in the bankruptcy court. I see that on the debtor's perspective, but I also see creditors, pro se creditors who come in and want to relitigate issues that were already litigated in state court. If that pro se creditor has a judgment, obviously that's the easiest path to filing a proof of claim, but otherwise it can be a little tricky when you're looking at the numbers. Is this contingent? Is this liquidated or unliquidated? So all of these are items that you want to discuss with the pro se creditor during this consultation to make sure that at least you have a good basis for the understanding of what they're coming forward to do. Let's see here. We already talked about the source, and I know that both debtors and creditors alike are using it. I encourage a pro se creditor to look at the source. There's so many good pleadings and documents from a creditor's perspective that you can go on to. Even the court also on the main page, we don't have to go there, but on the main page has some tutorials about what a reaffirmation agreement is, what a redemption is. A lot of times creditors are being pulled into these cases having no prior bankruptcy experience. Sometimes just the verbiage and the language alone can be oftentimes overwhelming, as I'm sure for the debtors it is as well. I think there's a lot of similarities here. It's just for the creditor's position, you typically do not have someone who is, they are more a la carte issues, I would say, than debtor representation in the whole case. A creditor typically will only have one minute issue in the case. On the pro se side. The other item I would like to discuss with any pro se creditor, and I repeat, say it early and often, is discussing the automatic stay. So it's important to relay to that creditor that the automatic stay goes into effect immediately upon the filing of the case. And also, depending on their type of obligation, to make sure that you understand and advise them on what they can and cannot do. Oftentimes, if you're dealing with, maybe it's a family member that's owed money, maybe it's that former employee, they're oftentimes still in communication, whether that's, you know, phone communication or more formal communication. And I oftentimes just want to make sure that we've discussed the importance of the automatic stay, not asking for money, not moving forward any case that could even be construed as asking for money, because you're already owed money. You don't want to be on the flip side where now you're in the position to defend yourself, or alternatively, you're forced to retain counsel because now you have to defend yourself against a motion for sanctions, or, you know, goodness forbid, you've now taken property from the estate and Mr. Rivero is coming after for a motion for turnover or some other type of motion. So early and often discuss the automatic stay, discuss that this is the only process that can come forward. Now that the debtor has filed bankruptcy, this is where all of the pleadings are going to be generated. There's some caveats if it's a family law issue. I have seen pro se creditors who are former spouses who come in. I don't personally handle family law, so I typically will phone a friend and ask for a consultation for another attorney locally that does family law. And it's easier on that side because that's when you can call Kelly, or you can call another debtor's attorney who they're not involved in this debtor's case, but they can consult because they have more knowledge on how that ex-spouse who may have a DSO or could have some other type of issue can be treated. On motions for relief from stay, I think they're underutilized by pro se creditors. You don't see a lot of pro se creditors filing motions for relief from stay. Luis and Kelly, tell me, am I wrong? Do you see a lot of pro se creditors filing motions for relief from stay in bankruptcy?
I do not. I can't think of an instance where I've seen one at all.
Yeah, I think that you can accomplish quite a bit with a motion for relief from stay. And it's my own personal opinion that you ask for permission and not forgiveness, especially in the bankruptcy court. So oftentimes I hear, you know, I lent someone money, or they've got my vehicle, or I'm being now served with something. Maybe they're not a creditor, but they're not the debtor, but they're a potential target in an adversary proceeding for a fraudulent transfer. They're a potential target for a turnover motion from the trustee. And oftentimes we see pro se individuals seeking their own self-help remedies versus filing motions for relief from stay. So the two big creditor issues that I see routinely are proofs of claims, and then issues where a motion for relief from stay would have done that person a ton of good, but now they're on the back end of the sanctions, motions for turnover nastiness, because they did not take any preliminary steps to try to protect their rights. So if that makes sense. I was also going to talk about, I'm on the Tampa Bay Bankruptcy Bar Association, and I ran the Pro Se Clinic a couple of years ago. And one of the things, I was candidly probably one of the attorneys who was shaking in their boots. I'd never done a debtor case. I still do not handle debtor cases. And I was being asked to come into the Pro Se Clinic and potentially assist, especially if we couldn't cover certain slots. The first time I appeared and attended, I will tell you, one, it gives you a sense of, you know, that you are giving back to the bankruptcy system as a whole. But two, I was afraid in my head that the person coming in was going to know more about bankruptcy than me and was on day one going to realize, you know, what do you mean you don't know how to do the means test and you can't tell me off the top of your head every single exemption that I could claim. That was not the case. Genuinely, it was someone who found themselves in a financial situation. They could not afford a lawyer, and they came with what I thought were actually very smart questions about what they could do in the bankruptcy system. Now, there's a couple caveats to that, because I do so much creditor work, represent a lot of credit unions, I represent a lot of institutional lenders. The very first thing I did in any consultation was either ask the person for a copy of their schedules or pull up their schedules on my own in Pacer. And that was ahead of even having a, hi, my name is Nicole Knoll. I need to look at your schedules because I want to make sure that I don't have a conflict. Pulled the schedules, reviewed. Now there's always a chance they've left a creditor off and that could be discovered later, but at least I had an assurance at that point that I wasn't engaged in the case because I'd look at the docket, but I would also look to see who their creditors were. And as much as I feel on the creditor side that the majority of debtors were coming in with mortgage issues and vehicle issues, and I was going to be conflicted out, I actually found some unique issues that pro se debtors had that were coming to the clinic. And it was much more nuanced than I thought it was going to be, meaning, oh, I'm going to give them advice that's in my client's, not, you know, my client's best interest overall. I found it to be really rewarding, but I will say, know the scope of what the pro se clinic is there to do, and also be prepared on your own dime at times to make sure that you've done a very good review of the docket, the schedules, so that you know that you're not conflicted out. And my last comment on this issue is, don't be afraid to phone a friend. Kelly knows, and there's a couple other debtors councils locally, that if I'm working the pro se clinic, I'm already asking them ahead of time, hey, if I need to call someone, are you going to be available? I had a case where a pro se debtor came in. It wasn't me, but my husband was actually representing the major secured creditor in the case. I wouldn't feel comfortable if I was on the other side taking advice from that person's spouse. So I immediately phoned one of our local debtors council who routinely volunteer in these situations. I stepped out of the room and they had a half-hour, 45-minute call on the issue. Same thing, not every lawyer does everything. They cannot expect us to. So when a person comes in with a student loan issue, I'm oftentimes going to phone a friend on that issue too, because that's just not something that's within my wheelhouse. But if you are a creditor and you're practicing creditors' rights locally, I would certainly encourage you to even shadow another attorney, maybe on their consultations, and that would be a good opening point. Clearly, Kelly and I are not in competition for clients. She does debtor work, I do creditor work. There's not going to be any conflict of sitting in with a debtor's attorney and gaining more experience on that end. There's no fear that I'm going to try to take clients. So I think that also will make a creditors council feel more comfortable in volunteering at the pro se clinic if maybe you do it with a friend the first couple times. Kelly or Luis, do you have anything on the creditors or volunteering when you're not a debtor's attorney? No? Okay. Well,
Nicole, you did a fabulous job, and I just want to pick up and add, pick up where you left off and sort of add the trustee's perspective as we wrap up today. If you have sat through this presentation this long, I want to thank you for answering the call and being committed to helping your community, the bench and the bar. Personally, from a trustee's perspective, it is oftentimes a similar perspective to that at the bench. Not only are you giving back to our community, not only are you serving our public, but you're assisting the court and the system, so to speak, administer these cases, push the cases through, and get to the right result. Because sometimes pro se debtors, pro se creditors, they just need a little bit of help. And who better to give it than to you, experienced and committed practitioners. Pro bono service, and in particular, the Pro Se Clinic, is a great opportunity for both younger and experienced lawyers alike. For the younger lawyers, you get client interaction. You have the opportunity to have experience as a lead counsel that maybe you might not have otherwise had. But even for the experienced lawyers, you get to broaden your substantive experiences and hopefully become a better lawyer by being able to view different cases and different experiences. And I'll tell you, don't be afraid. I signed up. I've never done a debtor case. I have signed up for debtor consultations, and I have my first one next week. It's only 30 minutes. I may not have done a debtor case, but I've seen the other side of most coins. And I think I'll be able to help, hopefully be able to help the client, but also the bench and the bar. And what I reminded myself is it's only 30 minutes. I can do this for 30 minutes. I can add value for 30 minutes. And beyond that, I can point them, after that, I can point them in the right direction. I can phone a friend. I can get them to where they need to be, because I will not be the right guy for a debtor's case probably. And I'll give them 30 minutes. So that's from my perspective, why it matters. And, I think it's more of the same that you've heard. Two things I want to follow up on, both Kelly's presentation and also Nicole's. The first, somebody mentioned document requests, and we were preparing, and we talked a lot about the source. One thing I want to remind you as practitioners that are volunteering in the Pro Se Clinic, right there in the middle, it says Chapter 7, 11, and 13 trustee pages. There you go. So every trustee in the Middle District of Florida has supplied information to the court, and it's by division. And so, for instance, you go to FTM, Fort Myers, you can click on my name, and there you know what my requirements are. You know how to get a hold of me. And you know what kind of service I use, what my preferences are. And on the left, there's supporting documents. You're going to see my standard document requests and what my procedures are for various issues. So for instance, I have signed up to assist in all divisions. So if I draw a debtor case and they're worried about their 341 and they don't know what Bob Altman in the Jacksonville division requires, this is where I'm going to look. And I'm going to be able to pass that information on, because the pro se debtor may not know where to otherwise find that information. And again, it's going to help you become a better lawyer, because you're going to see how other folks do it. And, again, learning new tricks of the trade. The other thing that both Kelly and Nicole touched on is valuation issues. And I'll just sort of give you the trustee's perspective. And it's similar to Kelly's. I think it's important to have disclosure, and it's important not to guess, and to have, meaningfully think about, what the value is. So Kelly talked about real estate, and it's probably going to be closer to Zillow than it is the property appraiser, and she's spot on. She's been doing this for a long time, and she knows what she's doing. The property appraiser is going to already discount the value for costs of sale. So that number is only going to be at most 90% of retail value. And not that it comes up a lot in Florida, but in the context of real estate, if I see that you're using the property appraiser's value, I know it's at least 10% more. Automobiles, big issue today. There's a lot of equity in automobiles. I agree with Kelly as well. You need to do your research and come up, explain. I think it's best to explain to the trustee why you put the value down that you did, as opposed to, or to your client or the debtor, as opposed to just making it up. There are a lot of cases that I have, both pro se and otherwise. I realize that the issue is going to be the car, and I suggest to the parties, hey, you may want to get an appraisal because the car is going to be the issue. Most trustees, software providers, going to give them automatically what the NADA, Clean Retail, and Kelly Blue Book values are. On my system, all I do is hover over the vehicle and it pops up those numbers for me. If the clean retail is 10 and you put 5, I want to know why. Is it because you only have a half interest, or is it, is the vehicle damaged? That's information I'm going to want to know. And then, at least down here in the Fort Myers division, I think an auto appraisal is often $75. I tell represented debtors and pro se debtors alike, sometimes that's going to be the best $75 you're going to spend, because you're going to cut off any kind of litigation or potential objections at the pass. And so those are the two things that I really wanted to touch upon, unless anybody in the audience or anybody on the panel has anything. Kelly, you have any questions you want to, anywhere you want to pick from the trustee's perspective? Nicole? All right, silence. I like it.
Well, we did really well on time. I want to thank all of our panelists. Judge unfortunately had to leave, but she asked that we relay all of her thanks to everyone out there who's watching and who intends to volunteer or take on a pro bono case. We appreciate everything. So from all of our panelists, thank you so much for watching. And we will have the CLE number. It will be included in a email out to the live participants, and to those who are going to later watch it on a webinar, it'll be included in that function as well. So thank you so much.
Thank you. Have a good day.